All right, all right. We are recording for the purposes of future usage, and for those that cannot be here today who were very, very much interested and wanted to partake. Just want to say, as always, thanks for joining us and making time. And it's nothing like doing these Zoom things, and the screen is just filled with names and pictures and people who got the camera on. So I'm grateful as always to have so many people attend this much needed information session. Another RELC lunchtime chat. Just filled with gratitude for what I've been allowed to do in this space. So I want to make sure I give a proper introduction, one that I think should include a recommendation of his work, his book. But I'm going to start with something that I think is important in regards as to how I met Paul. He was doing a talk on his book, The Thief, the Senator, and the Knight of the Bleeding Heart at Chapel Hill Library. Gosh, maybe 3, 4, 5 months ago. And I had shared it with the RELC members, and one attended, and it was my relative, Lisa, who reached out and said, "Are you coming?" And I was kind of on the fence, but since she was here, I said, "Yeah, I'll come join." And lo and behold, I run into Dr. Parker there, and it was a really, really good introduction to Paul via his work. And of course, within that time frame of interaction, I get to stand up there and have a brief conversation, and in seconds, I knew that there was something more substantive than a guy who wrote a book about some interesting people from our state. So quite a few times we followed up, and we've had lunch and talked about everything under the sun, including our current political state, which may find its way into this conversation because we're talking Constitution here. We're talking about North Carolina's Constitution, which of course is going to have some connections to our national Constitution. So we've had a pretty good interaction over the last few in the build up to today's presentation. And I'm looking forward to what Paul is going to share with you all, and how much I think he has to offer in this space. He's not a historian. He'll be the first to tell you that. But in this case, he's done a really thorough job of research and high level integrity based telling of history, which I can't say enough about. I've read some of it, haven't gotten through all of it, but it is well written, and it does a good job of articulating the complexities around Reconstruction, the Reconstruction era, and the political sphere of that time. So our state, Constitution, Reconstruction, and race is what Paul Greene is going to talk about. And I know for a fact he's done even more research than he had to do to have this conversation. So Paul, just lean in, keep that voice up so everybody can take what you're putting down. Say more about yourself if you like. You have a pretty interesting legacy with who you are. Actually, I think your namesake. But introduce yourself if you can do it better than I did, and let's rock and roll. Welcome, Paul. Thanks, sir, for doing this.
Thank you very much, Felton. Please raise your hand or do something if you have trouble hearing me, okay? And what Felton said, that I'd be the first to tell you. Well, Felton was the first to tell you that I'm not actually an historian, and I will just emphasize that. I notice in the people who are joining this Zoom, there's several folks who I know to be real historians. So raise your hand also if you see me straying into amateurism a little too far, and I need help getting back on track. The Constitution is a really huge, sprawling subject, and but it's an avenue of it's a way of looking into the past and maybe understanding it in a different way than you did before you used that prism for looking back. My background is as a lawyer. I've spent many years in mostly criminal litigation, death penalty appeals, criminal appeals, prisoner constitutional rights, and some class actions. So I'm familiar with a lot of these constitutional rights issues from the point of view of a lawyer, which is a very specific point of view, and it lacks some of the depth of understanding that you get, that's really necessary, that you get from reading history. And it was in writing this book that Felton mentioned that I really got into the way that North Carolina's Constitution came into being in 1868, and how the 14th Amendment, which I had cited innumerable times as a lawyer, but the story of how that came into being, I had only the vaguest awareness of. And seeing the actual facts about what happened, what people did, what they had to do, what they went through to get those provisions down in writing was really an eye-opener for me. And also a kind of a disillusioning, because the writing down of the words was like the easy part. Making those words into building them into the structure of society and the way people think. Well, we're still working on it. So a constitution, we think of it as a writing. Usually we think of it as having two parts. One that kind of is a formal description of the structure of the government, and another which establishes certain rights that the people have. And as I just said, and I think is apparent from modern news headlines, the fact that something is in writing doesn't make it so. And by the same token, the fact that something is not in writing doesn't mean that it's not part of the Constitution. I mean, the English famously have an unwritten Constitution, and a very important element of which is the Magna Carta. It established in 1215, and it has become part of the English Constitution, which was then adopted in the American colonies through the English common law. And the meaning of the Magna Carta, as we think of it, is that the king is not above the law, and that people who have been detained by the king or arrested have the right to appear before a judge and challenge the king's right to hold them. So those principles are there in the law, but if you go back and look at the Magna Carta, those rights only applied to a handful of barons. Okay, they didn't apply to ordinary Englishmen. That was only something that came through custom and history and practice and long experience. But now it's a part of the English Constitution, even though it's not written down. So if we want to talk about the North Carolina Constitution, I thought it would be helpful to go back a little farther than 1776, which is when the state of North Carolina first declared its existence and adopted a constitution. But let's talk about the Lords Proprietor. Okay, how did North Carolina come into existence? What were the customs and understandings of government when it before we had the Revolution of 1776? Well, we can't go back too far. We're never going to get to where we want to go. But we know about the early 1600s and the Jamestown colony and 1619 project about how African people were there, not voluntarily, but they were here, right along with the very first English settlers. It was in the 1650s that some of those Virginia colonists started just kind of migrating on down and claiming land and living in North Carolina. What was happening in England was that in 1649, King Charles I was being beheaded And then we had the Cromwell, a kind of a secular monarch leading the country. And then we had the restoration of Charles I's son, Charles II, in 1660, the restoration of the monarchy. So this is a time of incredible political turmoil in England while these settlers are coming down. So that's 1660, Charles II takes the throne. In 1663, he gives the Carolinas to 8 so-called Lords Proprietors. And they're by this stroke of the pen of the King of England, they become the owners of all of the land in the Carolinas. And that's, that's ancient history, but it's really important because it sets the stage for a couple of hundred years of history, which we're still feeling the effects of, where political power and land ownership they're the same. They're inseparable. So the Lords Proprietors, they want to make some money. So they consult the plantation owners in the Barbados, which has set up a sugar economy based on slave labor. And the Barbadian plantation owners, they look at the Carolina and they think, oh, land. They persuade the Lords Proprietors to establish a headright system whereby men, and we're talking men now, the women are excluded from virtually all of these political processes. If they can bring some slaves with them, they get extra land. That's called the headright system. The Lords Proprietors say, well, that's a way for us to get rich, and they buy into it. And South Carolina, which has got a very, it's geographically very suitable to this kind of large-scale plantations, ends up over the period of the next couple of hundred years having more slaves than free people. North Carolina is not, geographically, it's not quite as suitable, doesn't have as rivers, it doesn't have the low-lying areas that are good for rice. It gets a slave economy, but not as intensely as South Carolina. And you can see that today in the demographics of the two states. And you can see it politically in the way that South Carolina was very eager to secede and protect its slave economy, whereas North Carolina was very reluctant and only followed South Carolina's lead after it became unavoidable. So these Lords Proprietors, they're not just slavers, and I don't think that they're necessarily racists, although they may well have been. The racial ideas of the 1600s were so alien to the way we think about human beings today. I'm not sure that the term really translates back then. But what they clearly were is I would call them feudal authoritarian capitalists. They owned the land. They thought it was right that they owned the land, that they should that their progeny should inherit the land, and that there should be an underclass that's answerable to them and pays them rents. That's the way they thought society should be structured. So in 1669, at a time when there are not maybe a few thousand non-native people actually living in what we now think of as North Carolina, they wrote up a document which is supposedly written by Locke, which I think is contested. They called it the Fundamental Constitutions of Carolina, and it basically defined a feudal society. There was going to be a hereditary aristocracy of whom the Lords Proprietors would be the highest rank. There would be free men who could own property, and the main property they were thinking of was land and slaves. And then there would be a class of Englishmen called leetmen, which were basically serfs. They were thought of as being like part of the land. They were tenants. They paid part of their crop to their lord, and they couldn't leave that land without their landlord's permission. So they were not free. But these lords proprietors also recognized, hey, well, we've got these slaves. We have to provide for them in the Constitution. And there are two provisions in those original Constitutions. One, that the slaves should be under the absolute authority and control of the free men owners. And two, that they should have almost complete freedom of religion, which is interesting that those two principles exist side by side in this document. But the fact that they designed a society that would have essentially a serf class of European ancestry people, I think it's so alien to us now, and it never actually really came to be. But that's what they planned. That's what they wanted then in the 1600s. The economy and the population grew slowly. By the 1700s, by very early 1700s, there were some free Black folks. And there was no provision in the fundamental Constitution to treat them any differently from free white folks. And I think the records are just not there to establish exactly what was the attitude of the local officials towards free Blacks. But we know that some of them voted in the elections for local officials. And one of the reasons we know that is because there was a complaint. We've got people voting we've got Negroes who are voting. What's going on here? But the fact that there was a complaint shows that they were doing it. We had Black folk voting in North Carolina in the year 1701, I think. But then in 1715, the Colonial Assembly decided that no, free Blacks do not have the right to vote. They don't have the same rights as whites. Now, that was an act of the Colonial Assembly. That was the people of North Carolina, the white people, the landowners, the free men, getting together and deciding that they were going to take the franchise away from these Black folks. It was not part of the fundamental Constitution. But as I mentioned at the beginning, things that become established through custom and long practice can, for all intents and purposes, become part of the Constitution. So if a couple of decades later, the Colonial Assembly changed the definition of who can vote so that it was simply defined by property, not by race. But by then, the practice had established that white folks vote, Black folks don't vote. And it's unclear that Black folk voted or were permitted to vote, even though that racial provision had passed along. So we have a growing slave population, a growing free Black population, and white folk who, many of whom own land and slaves, many of whom don't. And it's all becomes wrapped up in the struggle over getting independence from England. In 1776, you have that beautiful Declaration of Independence. All men are created equal, except those who aren't. A little footnote there. And in North Carolina, there's a provincial Congress that gets together and says, well, we're going with the revolutionists, and we're going to adopt a constitution. Several other states had adopted constitutions already, and the North Carolinians based theirs largely on these others. And there's no leapmen, there's no serfs in this constitution. That idea, even though it had been written, was never really became reality. And there's some very interesting things about that 1776 Constitution. Well, it starts by establishing popular sovereignty. The people meaning the aggregate population, not in the sense of the plural of persons. And there's no hereditary privileges. And it makes reference, it starts with the Declaration of Rights. And it seems to assume that comes before we get a structure of government. We have to have a Declaration of Rights. And it's very interesting in this Declaration of Rights how they talk about the rights of freemen. No freeman should be arrested without due process, or deprived of life, liberty, or property without due process. But then it has some other provisions that talks to any person or persons or any man, and that would include slaves. So, or it would appear to me would include slaves. I don't know if the legal scholar would quite agree with that. But criminal prosecutions, every man has the right to be informed of the accusation, to confront the accusers, not to be compelled to testify against himself. Every man would appear to include every single person, including a slave. On the other hand, the state equivalent of the Fourth Amendment about search and seizure is just general warrants are no good. You can't issue a warrant just to seize any person or persons who aren't named with specificity and whose criminal offense, alleged criminal offense, is specified. That would appear to apply to slaves. And yet we have this practice of the slave patrol, which is exactly that, a general warrant, which allowed white men to basically go around at night and go into the houses of where the enslaved people lived and make sure that they weren't breaking any of the rules against trading or being away from, and they could summarily whip an enslaved person without any accusation of an offense or anything. So it's not clear that these were really extended to enslaved people. On the other hand, the freedom of religion. All men have a natural and unalienable right to worship Almighty God according to the dictates of their own consciences. Well, that was in the Lord Proprietors' fundamental constitution that specifically said slaves have a right to complete freedom of religion. And you can't mess with a slave's practice of their religion. So that clearly does apply across the board. But the thing that is, aside from these kind of ambiguous and minimal references giving some recognition to the humanity of enslaved people, is that the free men are not defined by race at all. And that was very consciously done, very clear that free blacks are no different from free whites according to the Constitution of 1776. And for many years, black men, women were not allowed to vote, no matter what your ethnicity, until the 20th century. But we have a report from Judge Ralph Buxton in his memoirs. He'd been practicing law since 1848 and had been elected judge for many years. In his memoirs, he says, yes, the votes of free blacks were very carefully sought after by candidates during that part of the mid-century, the 1800s. And I think that he was referring to an earlier time, because in fact, the Constitution of North Carolina was changed in 1835, took that vote away. As the economy was developing, the planters, and there were more and more free blacks, some of these property planters got the idea that, wait a minute, we're having a little bit too much cognitive dissonance here. We need to kind of clearly understand there's two kinds of people, not three or four. We want to have our racial categories more stark, and that pressure actually continued to grow over the years leading up to the Civil War. So the vote was taken away in a constitutional amendment in 1835, but what was preserved was the importance of property, and that was established in the 1776 Constitution. In order to be a senator, you had to own at least 300 acres of land, and if you owned 300 acres of land, chances were very, very high that you owned a number of slaves as well. To be a member of the House of Commons, you had to own at least 100 acres of land. To vote for to be an elector, a voter for the members of the Senate, you had to own at least 50 acres of land. So you couldn't even vote for the Senate if you weren't a landowner. To vote for the House of Commons, you had to at least have paid taxes. So you couldn't be a poor man. You had to have some standing in property, enough to pay taxes, some taxable property. So that is, by 1776, this idea that political power and land were one thing that really came from the Lords Proprietors and this grant of all of the land of the Carolinas to these 8 men, that had become entrenched. And it was written down in the Constitution of 1776. And when people have power, they always tend to want to preserve that power. And what this slave-owning, land-owning legislature did over the years was to enact laws that entrenched their power. And you had, I couldn't tell you exactly the years that these different provisions were enacted, but by 1854, when the laws were put into a single code, which you can get online and you can do word searches, it's a lot of fun to do. You had laws like whites and free blacks and slaves cannot play any games together. You can't play cards. Why do you have a law about free whites and free blacks playing cards together? It's basically, we don't want fraternization between the races. I mean, that threatens our domination and subjugation of this whole class of people who are our slaves. No trading with slaves. I mean, there's this whole the crime of sedition. To go out on the street and say things that called into question the institution of slavery was sedition. If you were disrespecting the institution of slavery in the hearing of slaves, you were basically inciting a revolt. Now, sedition is an uprising against the sovereign. What does the sovereign have to do with slavery? The Constitution doesn't say we shall have slavery. Well, by the time these provisions were enacted, it might as well have been in the Constitution, and for all intents and purposes, it was, because the entire state of North Carolina, the budget, the finances were dependent on slavery. When the crunch finally came in late 1860, and President Lincoln was elected, then governor of North Carolina, Ellis, he gave a speech where he explained, we can't do without slavery. If we look, if we have $11 million in annual exports that the state of North Carolina produces, 10 million of it is produced by slaves. Without slaves, the state of North Carolina could not raise $1 of credit. So that's entrenchment. That's we start from a few settlers in the 1650s coming in, a combination of white slave owners and at the beginning very few black slaves. That becomes part of, well, hey, we've got a money-making proposition here. You get this fundamental constitution based on the ownership of land and slaves. Then in 1776, you have the entrenchment of property without express reference to race, but implied reference. And by the time of the Civil War, it's so far entrenched that it might as well have been written in big, bold letters right at the top of the 1776 Constitution. It's a sad thing to think about because it could have been otherwise. So that's our 1776 Constitution. Well, meanwhile, we have the federal Constitution is being hammered out, and it's not completed for a number of years. The constitutional struggle over the struggle over slavery and the adoption of the federal Constitution is really interesting. If you haven't just kind of had the pleasure of just going through the original Constitution and just reading the whole thing, or get it on electronically and do some word searches. The word slave does not appear in that Constitution. And you can tell that there was there's books that have been written about this, but even on the text of the Constitution, you can detect the ambivalence and conflict that the delegates had about it because they didn't want to touch it. You have no reference to slavery. You have no express permission of slavery, but you have several backhanded acknowledgments that slavery does exist, and we're not going to. This Constitution does not take it away. Those provisions are most famously most infamously the 3/5 clause. The 3/5 clause is there because the delegates from the South and throughout the South, remember, these delegates are, I don't know if this is literally true, but most, if not all of them, would have been slave owners, land owners, certainly of the class of people who practiced slavery and believed in it. They were devoted to perpetuating slavery, even at the founding of the United States. That was such an important goal that they were not going to join in a union of states unless that economic system was protected. And the way they protected it was they said, well, you got to count, you got to give us, in the apportionment of members of Congress and the Electoral College, you've got to give us some credit for all of the slaves and enslaved population. And they talked different numbers. They talk about, we can't give you credit one for all these slaves. So it became a numbers thing. And they, I think three quarters was floated, one half may have been floated, and they settled on 3/5. And it was something the South demanded, and it was not going to get done if it wasn't put in the Constitution. So there it was, 3/5. So South Carolina, with more than half of its population being enslaved, had all these extra representatives in Congress for being a slave state. That had a real distorting effect on national politics for decades. And it's one of the reasons that we ended up having to fight a war in order to correct. But the interesting thing is not that this mistake was made, but that it had to be made in order to form the United States, because otherwise you would have had two different countries. The South, by that time, slavery was so entrenched, they were not going to do it without that. The other things that they required, the Fugitive Slave Clause. We've all heard of the Fugitive Slave Act of the 1850 Compromise. Well, the fugitive slave, recovery of fugitive slaves wasn't invented in 1850. It was written into the Constitution of 1789. It was the refusal of Northern officials and Northern government of Northern states to actually enforce this Fugitive Slave Clause of the Constitution that led to such resentment and hostility of the Southern states that the Fugitive Slave Act was okay. Well, we'll start prosecuting people in the North who violate this clause, requiring them to give full faith and credit. If you've got a judgment from a Southern court that says John Smith belongs to me as my property, well, the Northern court has to turn him over. And if you don't, there's a criminal penalty. Another way, which is not reading between the lines, but another way in which slavery, you can read it in the Constitution of 1789, is the fact that there is no definition of citizenship. The word citizen is used, the word people is used, the word person is used, but they never actually say, well, this is what constitutes a citizen. And I suspect, although I'm not enough of a scholar to know this for sure, that slavery is one of the reasons that they didn't go there, because if they were going to define a citizen, then they had to define in writing what a non-citizen was. And the only they never define it, but in the 3/5 clause, they refer to Indians not taxed and all other persons. Yeah, that shows you how proud they were of what they were doing. All other persons. So we have a civil war that I can't talk about the Civil War. That's another 6 Zoom sessions. Felton, I've already exceeded the bounds of my knowledge. We've reached the point where we have, after the Civil War, we have a proposed 14th Amendment. The South refuses to budge. We have the Reconstruction Acts. Then we
What's the 14th Amendment?
Well, first, 1865, while the southern states are still not part of the U.S. Congress because they've all seceded, we have the 13th Amendment, which basically puts an end to involuntary servitude. And that is a done deal while people are still fighting. And when the South ends up reconstituting itself, there is no going back. And even the diehard secessionists know that there's no going back on slavery. But what the rights would be of the recently enslaved was a very wide open question. Now, President Andrew Johnson was agnostic. It was kind of like, "Go thou secessionists and sin no more." Basically, his attitude appeared to be that well, we could continue to have these white supremacy republics be part of the United States. That's not the business of the federal government to say anything about that. Well, Congress was not going to go along with that, and they started holding hearings, and they promulgated a constitutional amendment that said several things. I mean, it disfranchised the secessionist politicians. It provided that if you were born in the United States, you are a citizen of the United States, which meant all these slaves were now citizens. Full stop, period.
And can I interject something, Paul? Because I know this, and I do want to allow time for some questions. But to that point that you just made, the reason why that can be uplifted in our present state, and if you guys are not aware, that came up immediately after Trump took office, this notion of the 14th Amendment having a specific group of people that it was assigned to and not intended to allow for people to come here, have a child, and claim some birthright citizenship. And that is literally what is about to be argued by the Supreme Court, that justification for someone who comes here. It was the 14th Amendment was to assign some element of a fledgling understanding of what citizenship was to all of these people who had been here generation after generation, but had existed in servitude. So just to kind of clean that up, but definitely want to leave time for questions, man. I appreciate all of what you've given us. So you can put a bow on it if you like, and we can address at least one of the questions in the chat. Let me
try to put a bow on it. The 14th Amendment guaranteed the right of due process of law and equal protection of the law. Due process of law goes right back to the Magna Carta. The equal protection of the law, that was kind of a new thing, and I think it was with the enslaved people in mind, largely. A very little discussed part of the 14th Amendment was another section which said that basically it said the 3/5 clause is no more. But if you southern states deny representation, deny the right to vote to any of your citizens, then your apportionment of congressional representatives will be reduced by the proportion of citizens to whom you have denied the right to vote. Stated otherwise, you southern states, if you want to continue to deny black men the right to vote, go right ahead, but you're not going to get the benefit of the 3/5 clause anymore. And Frederick Douglass kind of pointed out, are you kidding me? You're telling me that I'm a citizen, and in the same breath, you're telling me that a bunch of other citizens can take away my right to vote? So that was how the 14th Amendment was proposed. The Southern states still wouldn't accept it, even though it gave them an avenue to preserve a great deal of the white supremacy social system that they'd set up. And that is when Congress enacted the Reconstruction Act, saying basically, okay, forget it. You're not going to play ball. We are going to declare that all of you southern states no longer exist. You are simply areas of territory that are presided over by a Union general. And that Union general is going to preside over elections in which Black men can vote. And at those elections, you will adopt new state constitutions which grant Black men the right to vote. And that is setting the stage for the Constitution of 1868, which did exactly that. Did away with the property requirements. It basically put a stop, or tried to put a stop, to this very irresistible force of land ownership, which has just come down through the centuries to basically crush anybody who didn't own land. And that's as much of a bow as I can put on the 14th Amendment. The Constitution of 1868 was revolutionary, gave Black men the right to vote, and was followed almost immediately by the formation of the Ku Klux Klan and the outbreak of violence, which is what my book was about. I thank you. You all have been really patient. I would like for some of the historians among you to step in and start cleaning up whatever I made a mess of.
We'll do that in an orderly fashion if it occurs, Paul. I appreciate you sharing all of the things that you have looked at with a microscope, a lens that needed to be cleaned off a couple of times, I'm certain, after some of the mess that you have to get through, because politics is a messy game and has been for a long time. A long time. The things that have been argued and debated, the things that we think are settled or not settled. We've seen that in real time in the last few years when it comes to something like Roe v. Wade. So never, ever think that these matters are completely and totally settled, even though, from a logic standpoint, they should be. Speaking of which, I'll just make a couple of comments. I'll get to Deborah's question in the chat. If you have questions, please raise your hand now. And I know Paul is desiring to hear from Dr. Parker, Dr. Elliott. So if you have any commentary, please feel free to share it. We'll have another conversation on Reconstruction, the Reconstruction era, and some of the constitutional stuff. Rob Skelton is on this call, and he'll follow up with a broader based conversation. His focus has been Florida, which also leads him to looking at how this is taking place across the South and during that time. So this will be a double up, and Paul, I hope you can make that one and interject some things as well. But one of the things I wanted to recommend, book was in arm's reach, so I had to share it with you. Can't read it, but it's Slaves Without Masters by Ira Berlin. That is a work that touches on some of what Paul was speaking about in terms of the complexities associated with being free and of color and in the way that it meant back then in the South. So yeah, that's a work that explores the complexities of that. Also, just want to highlight before I get to Deborah's question, look, never ever let someone, first of all, tell you that the Civil War was not about slavery. It was all about slavery, because when you have this much land, when you have the desire to develop a country, you need labor. And that is all it was about once it was understood that these people can be otherized and brought to a place of usefulness that does not allow for their humanity to be recognized. And lastly, the 3/5 clause, as was very well articulated by Paul, was not about the humanity. There was no humanity being recognized. It was all about political purposes of counting and representation of Southerners in the United States government. So Deborah brings up an interesting question. I'll say something, and then if Anybody else has more nuance, please make that known. Paul, of course, you presented today. So she's asking, didn't the use of the slave Bible in the 1800s contradict the Lord Proprietors' fundamental constitution intended to give enslaved people the right to complete freedom of religion? The religion had to be under some measure of control, Deborah, and Black folks were not, were lawfully restricted from being literate. So I think we all just have to recognize the conundrum that exists in any allowing of religious freedom in that regard. But Paul, if you want to add something, or anybody else.
Would like to add something, Felton.
For it, Ajane. Thanks. I'm glad you can make it.
Yes, I'm here, y'all. Doing end of semester things simultaneously, but I'm here. To that question, one thing I always stress is understanding the way that historical context works, right? And I know that Deborah Boston is asking this question because you understand that, and I so love that you put it in there. But I just wanted to add that questions like this are vital when we study history, because there are multiple parts of the law. A lot of Black historians argue, you can't necessarily legislate the sentiment. And so there's what's written on paper, and then there are the practices and the applications of the law and the execution of, justice. And so making sure that, when I sit down and study, that I'm understanding that legal history is a framework by which they're intending to propagate that this is what the values are of this society, and that the practices often tell a very different story. That the practices are that, because people will say, oh, the law is black and white. Unintended, right? The law is very black and white when you pay attention to the gray, which are the practices. And particularly with things like the slave Bible, in my research looking at environmental and medical history in Northeast of North Carolina, one thing I find is that Black writers, even before 1800, they are articulating what citizenship is and should be before these things are even put into the law, right? And so when we look at the way the law is talking about or purposefully navigating around conversations about defining citizenship, Black people know this. And this is why we, are able to now stand on the shoulders of Black ancestors who say, no, we're pushing for this nation to embrace what these laws and what these values should be in a full scope, because we know what citizenship is, right? And so taking into account all of these things, we just get a really robust story about really about the truth of what this country is and what they've done. So thank you. I just wanted to say that.
Great comment. Appreciate that. Anybody else have anything they want to put on the table? Yeah, CJ, go ahead.
Yeah, so I'm sorry I can't turn my camera on. I'm doing this from my phone. Just to provide a little local flavor to what's going on. You've got the Moravians in Salem who are educating, they are allowing their enslaved workforce to worship with them up until about this 1800, 1810 mark. And even after they exclude the enslaved population from worshiping with them, they're still allowing them to do their own worship from their wherever they're living at in the community. And then actually 1820, they start doing their own missionary work within their own enslaved community, trying to bring them back into their congregational fold. So I think to the point that was just made about the gray and just the complexity of history, the Moravians are unique in how they approach slavery and bringing enslaved people into their congregation. And I think it just adds an extra layer of complexity that's interesting and helps highlight some of the discrepancies and um, the worst parts that we see of slavery in America.
Very complex indeed. As you can tell, Paul, you have some pretty wise folks on this call. I want to read something from Douglas himself, from the man himself, and I've shared this before in another space, but this speaks to that complexity, and it also speaks to what Ajane was saying about the awareness of the gravity here of what was taking place as the United States was changing, and the awareness of the critical importance of being engaged and involved. So I'm going to try to read this from my phone. I am sorry to say, this is Frederick Douglass, I'm sorry to say that some of our number, only a very few men who have more learning than common sense, have been making concessions to this degrading idea. The idea that he's speaking of is that the Negro doesn't know enough to vote. They have been writing to Mr. Sumner and sundry other white gentlemen in different parts of the country asking them how to vote. Now, if we colored people are so destitute of sense and political I've always had trouble with this word, whatever, as to ask the white people how we shall vote, it might be well to confine all voting to the white people and thus save the trouble and expense of counting our votes at all. Basically, he's talking to black men about them having conversations with white politicians about how they should vote. Your best interest is how you should vote. That is paramount in that part of newfound rights and enfranchisement. And Douglas is calling that out, and my apologies for that word. I knew I was going to struggle with it. I always do. But yeah, anybody have any other comments, anything else they want to share or ask? Again, this will be a kind of, we'll have a follow-up to this conversation. I don't see any hands. Paul, any final words? Go ahead.
Yeah, I wanted to just follow up on what another speaker said, emphasizing that the practice and what's written down can be so divergent. And one of the most flagrant examples of that is the 15th Amendment, adopted during the same period to guarantee the right to vote. And that was also the year in which the Ku Klux Klan really achieved its aims in North Carolina of taking over the General Assembly and starting to roll back the provisions. Now, it took a few decades before they actually managed to take the vote away from pretty much all the black folk in the South. But by 1900, our Constitution had changed, and we have this grandfather clause, this preposterous workaround where you have some election official making a judgment about whether or not each voter can read, unless the voter is white, in which case, if they had a grandfather who could read in 1867, they could vote anyway. And the history of the disregard of the 15th Amendment, the thing that's so infuriating about it is not simply that the southern states did this, but that the national government let them do it. It wasn't until the 1960s, with under pressure of very courageous public demonstration, people putting their bodies in harm's way for the whole world to see, that we finally got the Voting Rights Act. And now I have a little diatribe, if you wouldn't mind my sharing with you just some. Remember when we got Obamacare, we got this tentative step towards universal health care, and then as soon as the Republicans gain power again, they want to roll that back. They want to turn back the clock. I thought, okay, well, that's just the give and take, 2 steps forward, 1 step back. Then it turns out, well, they actually want to roll back some other things, and they're really working hard on voting rights through lots of other means, identification, anything that will kind of chip away at the people's willingness to vote. They're not going to come out and say, well, we really want to do away with the 15th Amendment, but that's what their target basically is. And you say, well, oh my gosh, they want to go back to the civil rights revolution of the 1960s and roll some of that back. And a little time goes on, and they start attacking all the government programs, the welfare programs, the Medicaid, the expansion of governmental concern for people's basic well-being. And it's like, holy cow, they want to undo the New Deal. What is going on with these folks? And so we get to the Trump administration, and there's a full bore attack on the Department of Justice. They seem to want to not have the federal laws to be enforced. And when did the Department of Justice come about? The Department of Justice was established in 1870 to make to bring some enforcement to the acts that Congress had enacted to try to deal with the Ku Klux Klan. That was one of the major reasons that we have the Department of Justice in this country. And there were other, that was kind of a wake-up call for everybody that, hey, this federal government has got to be more active in lots of different ways in order for this country to hang together. It was kind of an epiphany of the Civil War era. And doggone it, if this administration doesn't seem to be very unhappy with some of the things that happened during Reconstruction. So I just continue to be shocked. And then last week, I read that the Trump administration, Steve Miller says, we're looking at suspending the writ of habeas corpus so that we can deport people without any due process or judicial review whatsoever. And it's like, are you, wow, this is like watching some kind of, really florid fungal growth in a petri dish. Whoa, I didn't know it would turn that
Fahrenheit 451, yeah.
Yeah, I mean, that's the Magna Carta. This is 1215. This is like bedrock of the Anglophone legal tradition. That you get when the sovereign seizes somebody, you have a judge that that can look and see whether it's legal. That the king is not above the law.
Yeah.
So
I think you got your wish, Paul. You got a historian's historian that's want to say something to you or say something today. There you go. Go ahead, Dr. Paul.
Hey, Paul. Hey, thank you for this, Felton. Thank you, Paul. I stand, I don't know, for the last 3 months, I stand in a position of being at the highest level of festivity with the spinelessness of Americans. This conversation reminds me so much about how far we have not come, that we are probably worse off in 2025 than we were in 1968. And I mean that sincerely. I think that when we have made the kinds of gains that we have made up to 1968 and beyond, and then look around today and see that indeed we are on our way back to a period prior to 1900. I'm talking about it's just as bad or worse in some cases than it was in 1900. And what really bothers me is just how spineless and how pusillanimous Americans are in their willingness to accept. What I'm saying is that you're not doing this from your heart. You're not loving people from your heart, being forced to love people. You're not abiding by what the Constitution says you ought to do because you believe it's right. You're doing it because you believe you're being forced. And I'm just at a point now that I'm more pessimistic today than I was 20 years ago, 40 years ago, and before 1968. And my hope is that that white Americans will just grow a spine and fight the power to the extent that you fight. And that is something that I see we're not doing. So I'm very disappointed and have a downcast look about where we are in America today, as opposed to where we were just 25 or 30 years ago. But Paul, thank you for this, and these kinds of discussions are the kinds of discussions we need to have, because oftentimes people don't even know that the problem exists. And if you don't know the problem exists, then of course you don't do anything to fight. So first of all, it's important that people understand that indeed there is a problem. And hopefully from that point, you will explore the avenues and roads that will lead you to doing something about the otherness that I see around us every day. Thank you.
Appreciate them comments, Dr. Parker. The jelly in the spine has got to be removed, and we got to do better. I totally, wholeheartedly agree with that. And people have to stop moving because there's something in it for them, and move because integrity, morality, care, and love dictate the movement. And I'm so glad to be in this space to share that sentiment with so many of you. Paul, I'm going to give you the last word, so go for it, man.
I wish I had gotten through what I did get through faster, because we didn't get to talk much about the Constitution of 1868.
We'll do it again. We'll do it again. We'll follow up. So no worries on that. This was robust enough. And you got to have a beginning. Origin points matter, and you did a good job bringing us from where we actually began. So let's just make a part 2, and maybe we can have a discussion with you and Rob at the same time. So go ahead, Paul. Give us the last words.
The last thing I wanted to say is just what Dr. Parker said. What's going on in today's national politics is absolutely appalling to me. And I don't have a sense of what the people, this is kind of vague reference to what's really millions upon millions of individuals. But when you have an institution like a large, powerful law firm that has no, all the principles that people who take the bar exam and say that they're lawyers and they're going to uphold the rule of law and defend the Constitution and all that, and then you have some of the most powerful among them who just say, well, we didn't really mean that. We've got some bottom line here. We might be, I think, as one commentator said, hey, if we don't knuckle under to this fascist tyrant, we might make only $15 million next year as opposed to the $25 million that will be. I mean, it's the failure of institutions is so apparent. Now, as an individual, I'm struggling to figure out what can I do. I mean, I've been out on several demonstrations. I've got a very cool sign that I made. The first time in my life, I'm actually going around carrying a sign. I've made some phone calls to Senator Tillis and Senator Budd. If Freddie, I mean, Dr. Parker, if you've got some other suggestions, I would like to hear them. I'm not sure what individuals should be doing. I think there's a lot of people struggling.
This is a part of that, Paul. This is what you should be doing as well. Don't minimize this. This is important. So I'm giving you credit for this as well. All right.
I'll take credit where I can get it.
All right, man. Well, listen.
Thank you,
hey, thank you, Paul. I greatly appreciate it. And this means we have to do it again. I'm grateful for all you guys that were able to hang around and just you know, spend this quality time with us for another RELC chat. I want to make a quick updated announcement. Miss Romalita Harrison will be doing her chat very soon. Some issues came up and we had to do what we do in this space, you know, move around on a couple of things. So looking forward to that and some other things coming up in the next few months. You guys will be made well aware of before we get to that point. Ricky, appreciate you as well. Great comments for you, Paul, in the chat, and Dr. Parker, appreciation for your contribution. Janae, of course. Look, we have to do these things so that we collectively, those of us who are out here trying to make a difference in some way, understand that others are with us and we have support. So I'm grateful again. Thank y'all so much. Everybody enjoy the rest of your day and week, and take good care. Stay dry, because we just got a lot of rain going on.
And Felton, thank you for hosting us.
Absolutely, man. Absolutely. Y'all take care.